A very warm welcome to lesson number 19 in our 50-part series on the law of evidence. In today's lesson, we will be discussing section 11 of the Indian Evidence Act. Let us jump into the section straight away. Have a look at the title of section 11. It talks of facts which otherwise are not relevant, but they become relevant under certain situations. Well, this makes a lot of sense given that we are dealing with chapter 2 of the Act. So chapter 2 deals with relevancy, and all of the provisions there are either meant to declare a certain fact as being relevant or they declare the fact as not relevant. So that is what we expect from a section that is in chapter 2. So chapter 11 talks of facts which otherwise are not relevant but become relevant under certain conditions, and basically these are the conditions as you can see under subsection 1 and subsection 2 of section 11. So whenever we study relevancy, it is important for us to give ourselves this reminder. The first of section 3, which tells you as to what the meaning of relevant is. And then we look at section 5, which tells you that evidence can be given only for relevant facts and facts in issue, right? Now, how do you decide as to what is relevant and what is a relevant fact? Well, for this, you look at the relationships that have been given, the connections that have been given in the sections from 6 to 55. So basically the provisions here would either declare a fact to be relevant or they would declare them not to be relevant. In other words, they would declare them to be irrelevant. So that essentially is what you see in all of the provisions between 6 and 55. So you know that when you're looking at any one such provision, you basically have a relationship which is given in that section between one fact and another fact. This relationship is signified by certain words which are given in the section. For example, when you speak of section 6, the key word for section 6 is the word transaction, right? Likewise, we saw section 7. The key words there: cause, effect, occasion, opportunity, right? Likewise, we saw section 8, which speaks of motive, preparation, and conduct, right? So we know that there are these words that signify as to what that relationship is. So when we look at a new section like section 11, again, we are basically looking for the words that assist us in making a fact relevant under section 11. So that's exactly what section 11 does as well. Section 11 basically makes one fact relevant. In other words, it declares it to be relevant by virtue of its relationship with another fact which has been mentioned in section 11 itself. So we look at the relationship given in section 11. That relationship would be understood by virtue of the words mentioned in there. And as a result of that, a certain kind of fact, the new fact, one fact, is made relevant. So now we look at section 11 once again. The title of section 11 reads, Facts not otherwise relevant become relevant. That's obviously the role of section 11. So now, 11 subsection 1. Facts which are otherwise not relevant are relevant if they are inconsistent with any fact in issue or relevant fact. So you see this? The new fact is the fact which is not otherwise relevant. This is the first fact, which is being made relevant by section 11 by virtue of its relationship with a relevant fact or fact in issue. Because you can see here it says with any fact in issue or relevant fact. And the word that is used here is inconsistent. So we see the word inconsistent, and then we have a fact, the new fact which is being made relevant by section 11, and its relationship with fact in issue or relevant fact. Okay. So just note this, the first word that we see is inconsistent. We see that in 11 subsection 1. Then we go ahead to 11 subsection 2. So again, read the sentence again from the top. So it says, facts otherwise not relevant are relevant if, by themselves or in connection with other facts, they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. Right? Which means, again, you have the same relationship of the new fact. So the fact, right, which is being made relevant You have a relationship with what? Again, relevant facts and facts in issue. So relevant facts, facts in issue. This time the word is slightly different. It talks about probable or improbable, right? Now, what is the difference between inconsistency and improbability? This essentially is the meaning that we have to gather in order to be able to understand Section 11. Section 11 of the Act incorporates what is known as the plea of alibi. You might already be aware of this because this is something that you commonly see in movies, books, and other places, right? I'll talk about that in a little detail later on, but for the time being, let us see one example. Let me give you a fact. The fact is that Ankit was in Chandni Chowk on Saturday. Now, this is a fact that is otherwise not relevant, right? So you see Section 11 reads, facts otherwise not relevant. So Ankit's being in Chandni Chowk on Saturday, well, that's a statement that's otherwise not relevant. But if it has a relationship with the fact in issue or relevant fact, then maybe it could be relevant. So let us say it's a fact that is otherwise not relevant, but if Ankit is accused of committing murder in China on Saturday, right, on the same Saturday, to clarify, it's the same Saturday. If Ankit is accused of committing suicide in China on the same Saturday, we've got our fact in issue here. Did Ankit commit murder? Now, when you see it in relation with this, it becomes relevant, right? It becomes relevant because otherwise one has to travel from Chandni Chowk to China, which maybe is not possible on the same day. Now the question is, these two facts, the fact number one, the fact that has been introduced by Section 11, and fact number two, which is the fact in issue, there is a relationship between these. Now my question is there an improbability of these two things to coexist, or is there an inconsistency between these facts? I want you to pay attention. I'll repeat that for you. Ankit was in Chandni Chowk on Saturday. Fact number one. Fact number two. Ankit is accused of committing murder in China. Or in other words, Ankit committed murder in China. Fact number two. So fact number one, Ankit is in Chandni Chowk. Fact number two, Ankit is in China on the same day. Is this a case of inconsistency, which means one fact is inconsistent with the other, or is it a case of improbability, that one thing is improbable when you look at the other thing? Take a moment and think about it. Let us look at one more example, and this time we see the illustration to Section 11 itself. This is the first illustration. The question is whether A committed a crime at Calcutta on a certain day, okay, which means it tells you the fact and issue, okay. Now, the fact that A on that day was in Lahore is relevant. Now, is this because of inconsistency or because of improbability? Which means that let us say A on a certain day is in Calcutta. Fact number one. A on the same day was at Lahore. Now, are these two things inconsistent, or is it improbable that one can be in Calcutta as well as Lahore on the same day? Well, it's important for us now to understand the difference between inconsistency and improbability. If you think that it is absolutely impossible for somebody to be in Calcutta and Lahore on the same day, that would be an example of inconsistency. Two things that cannot simultaneously coexist, right? If you believe that it is possible to go from Chandni Chowk to China on the same day, well, then that is something that is improbable, right? It's unlikely that a person would go from Chandni Chowk to China on the same day. However, let's say the journey is very long and it is not possible for a person to be in Chandni Chowk and China on the same day, that would be a case of inconsistency, right? So I understand that Chandni Chowk and China are quite far away, and therefore maybe I would say in the previous example that it was a case of inconsistency. Likewise, in this case, it is a case of inconsistency. Let me also tell you a few things. The Indian Evidence Act is an act of 1872, right? In 1872, you did not have flights, right? Which means that to travel from Calcutta to Lahore, it definitely had to be a train, and a train was not going to take you from Calcutta to Lahore or Lahore to Calcutta in one day. And therefore, given that background, you would say that it is a case of inconsistency, right? And therefore, it can be said that the fact that A was at Lahore on the same day is relevant under 11 subsection 1, because subsection 1 talks of inconsistency, right? Let's look at this thing a little further. The fact that near the time when the crime was committed, A was at a distance from the place where it was committed, which would render it highly improbable, though not impossible. So let us say the murder was committed in Calcutta, okay, but maybe A was in Assam, okay. Now it's at a great distance, undoubtedly, but it is not impossible for a person to reach Calcutta from Assam on the same day, maybe, right? So you can say that it is highly improbable, and therefore the second sentence, the fact that, let's say, A was in Assam, is something that would be relevant under 11 subsection 2. So 11 subsection 1 deals with inconsistency. Inconsistency means that the two facts absolutely cannot coexist. Improbability means that the existence of one fact makes the other fact quite improbable, right? So we see improbability. And it's not just any improbability, but it has to be highly improbable. Okay, let's look at the second illustration to section 11. The illustration B is quite interesting. So the question is whether A committed a certain crime. Okay, this is the fact and issue, of course. Now, let's look at it a little further. The circumstances are such that the crime must have been committed by either A, B, C, or D, right? So it is known that one of these four has committed the crime, and now the fact and issue is whether A has committed the crime or not, right? So this is the question before the court. Okay. So the circumstances are such that it is one of these four people who has done it. Now, every fact which shows that the crime could have been done by no one else. So what we understand is that if there's a fact that shows that only these people could have done it, there was no E, there was no F, no one apart from these persons who has done this. That is a relevant fact. And also the fact that it was not committed by B, C, or D. So we know there is nobody else, there is no E, there is no F, there is no G. Also, you know that it is not B, not C, and not D. That's what it's saying. It was not committed by either B, C, or D. Now, what do all of these point towards? All of these basically point towards the guilt of A, right? So these facts, the fact that D has not done it, the fact that C has not done it, B has not done it, E has not done it. Now, these are facts that are otherwise not relevant. Maybe some person called Z has not done it. It's otherwise not relevant. But once you are able to eliminate all of these, it increases the probability that A has done it, and therefore it is relevant under section 11, right? A little question for you. Is it relevant under 11 subsection 1 or 11 subsection 2? You can let me know in the comment section. When we talk about the plea of alibi, well, alibi essentially means elsewhere. So when a person is elsewhere, he takes the plea of being elsewhere, which is called the plea of alibi. Okay. It's important for you to remember that the plea of alibi is not a general exception under the IPC. So you know that there are certain pleas and defenses that can be taken under chapter 4 of the IPC, right? From section 76 to 106. So the plea of alibi is not one of these. It is simply a rule that is found in the Indian Evidence Act. Let us look at this a little more closely. Let us say we are talking about the plea of alibi in a criminal case, okay? As you know, in a criminal case, the burden of proof, the burden of proving that the accused is guilty lies upon the shoulders of the prosecution. Therefore, the prosecution must first discharge his burden of proof. And thereafter, if he succeeds, only then would the plea of alibi be considered. Now you might wonder as to why you would need to wait for that to happen. Well, if the prosecution fails, it means the accused is not going to be convicted anyway, which basically means that until he has discharged his burden of proof, there is no need for the accused to even make this plea of alibi. He doesn't need it, right? But once this burden has been discharged by the prosecution, the court is reluctant to take evidence of alibi, right? So now the accused, whose guilt has been proven by the prosecution, has to work hard for the court to take his plea of alibi, which means the court wants very reliable evidence to suggest the plea of alibi. It will not accept a weak piece of evidence for the plea of alibi. It's a very important point. To understand this, let us take the example of the infamous case of Dhananjay Chatterjee versus the state of West Bengal. So you see, this was a case where Dhananjay Chatterjee was convicted for the rape of a teenage girl, the gruesome rape and murder of a teenage girl, and as a result of which he was awarded the death sentence, right? So in this case, the court held that the plea of alibi requires to be very strong and cogent. You can't be giving a weak piece of evidence for the plea of alibi. So in this case, the court rejected Dhananjay Chatterjee's plea of alibi, citing that it was belated, vague, and only an afterthought, and therefore it did not inspire the confidence of the court. Okay, so you understand that the plea of alibi requires to be very strong once the prosecution has succeeded in establishing that the accused is guilty. As usual, we shall conclude with a little question. Now, we just saw that the prosecution is first required to discharge its burden, right? And now I'll ask you a little question relating to the general exceptions. We just saw that the plea of alibi in some ways resembles the general exceptions, right? Although it is not. We saw that the general exceptions are given in the IPC, and the plea of alibi is merely a rule of evidence that is given in the Indian Evidence Act, right? But some of the principles are similar. So you see, again, the need for general exceptions arises only after the prosecution has discharged his burden. Because if he is not discharged his burden, the accused doesn't need it. He is going to be acquitted anyway, right? But once his burden is discharged, once the prosecution discharges his burden, then the burden of proof of the existence of an exception shifts onto the accused. Let me give you an example. So you have on the one hand the accused, on the other you have the prosecution who's pointing a finger at the accused, right? This is the judge. Now, the burden of proof that this person is the accused lies on the prosecution. Let us say he now succeeds in doing that, which means that the burden of proof has been discharged by the prosecution. The court now believes that this person is guilty of the offense that is being stated by the prosecution. Now, if he wants to say that, okay, there's a general exception, I am actually less than 7 years of age, or maybe I am of unsound mind, or maybe he wants to say that he acted in private defense, any of these general exceptions, the burden of proof lies on the accused, right? Now, he has to prove that he is either a minor, not a minor, under the age of 7, or he needs to prove that he was of unsound mind, and so on. Now, my question to you is, in which provision of the Indian Evidence Act do you find this rule? So, I hope this lesson was of some use to you. You learned something from this. Thank you so much for your patience. Good day.